the premise that says there is a proscription. And my point is, my understanding is that other nations also have this as well. And this, to my mind, might be of relevance to the question of rationality, especially if, as you do, you accept that the court is not bound by the evidence or lack of it proffered by the state organ concerned.
No, I take the point, Justice Malanga. On the assumption, well, let's put it this way. On the assumption, and again, I'm arguing off the assumption that there is a proscription on South African citizens holding dual citizenship. Would it not be rational, well, if that's the goal, that's the legitimate purpose of the legislation to deal with that proscription. The question then arises, well, is 6.1a read with 6.2 an implementing tool that is rationally connected to that legitimate government purpose? I suppose that's how the question would be framed.
No. I want a response as to the possible basis why other nations would also have a problem, even if there are exceptions, but an initial problem with dual citizenship. And I'm asking that because, who knows, based on why those other nations have this proscription, one may be able to say, well, this is actually justified. There is actually a rational connection. Especially because you've accepted that we don't have to look to the state organ concerned only.
No,
we may look outside of that. So why do other nations proscribe, even if with exceptions, dual citizenship? Has the DA looked into that at all?
Well, we haven't, in the sense that we didn't need to, for the reasons that we articulate, that even if there is a legitimate purpose, and the question then becomes, is the means used to achieve that legitimate purpose, is it rationally connected to that legitimate purpose? So is 6.1a in its form rationally connected to the legitimate purpose of proscribing dual citizenship? That's why I wanted to put the question to you slightly differently. And the answer is, we submit that it's not rationally connected, and therefore the question doesn't arise as to why would that purpose be legitimate. So I'm assuming that it's legitimate, that where there is a proscription on dual citizenship, I'm assuming it's legitimate for purposes of the debate. We haven't looked into whether it is legitimate or not, because even if it is legitimate, 6.1a doesn't achieve that which is sought to be achieved. Let me just go further and say a legitimate purpose must be seen in the history in the light of a particular country, and to look at why other countries and how other countries.
If we were at section 36(1), I would immediately say that's not the position, because because section 36(1) actually expects us to look at other open and democratic societies. So if we were at 36(1), I would take issue with your submission. But now your main argument is outside of 36(1).
We're not in 39.2. It's 30. Yes, 39.
Please continue.
Yes. I mean, 36(1) kicks back to 39.2, and we don't have that here because we're outside the bounds of 36. Okay. But I wanted to go further than that. In South Africa, citizenship is of a particular. It's got a particular. This court has said it over and over. It has a particular taste, a sour taste or a positive taste, depending on how one sees it. And therefore, what might be good for some other country would not be legitimate for South Africa in the context of the taste of citizenship in South Africa. It's got a particular history, and this court has said it. It's in our heads of argument, the importance of sort of the badge of honor. And the question is, if there was to be a proscription, to have that badge of honor and the taste of citizenship taken away in the way it's done by way of 6.1a, we would find not to be rationally connected to that prescription. Therefore, one doesn't even get to the legitimate purpose. But we still submit whatever that legitimate purpose is. And I'm really sorry, Justice Majid, that I can't find this where it's said in the answering affidavit, paragraph 25. I'm told not that paragraph 25 of the answering affidavit where there is a definitive statement to say no, it's not 25. I'm not sure where it is. I must apologize for this because it jumped out at me where.
Can I suggest that you finish your answer to Justice Madlanga, because I've got a question
Yes.
on paragraph 50, which is the only place where it is actually.
Yes, sorry, Justice.
Please finish with Justice Madlanga before I get to that.
Yes, Justice Malanga.
If you are done with your last response, that was my last question. Thank you, Mr. Kaz. Thank you.
Yes.
Oh, thank you. May I, Chief Justice? Paragraph 50 is the one I had in mind. That's the only place that I thought I saw it and I couldn't pick it up the second time. Dual citizenship is permitted by the Act, but it says that's permitted in terms of section 6.2. Now, even if one accepts your reasoning and argument for purposes of a judgment that 6.1a falls doesn't pass muster because just basically simply on the basis there's no legitimate purpose. So you don't even get to rationality and justification analyses. Mustn't one in any event then still interrogate section 6.2 for the limited purpose, Mr. Katz, of asking if the Act permits dual citizenship based on the minister's discretion, one must deal with it, and just prima facie, it seems to me the SA is absolutely correct. This is an untrammeled discretion, undefined. Yes. It's completely devoid of Audi, any administrative justice, and so on. But the point is one must interrogate section 6.2 for that limited purpose, because it seems to me, and as Justice Madlanga has correctly said, one must look to see where there could be any sort of purpose advanced in the Act. In other words, section 6.2 for giving for dual citizenship being permitted by the minister, by a member of the executive.
Yes, only, the Supreme Court of Appeal paragraphs 31 and 32 of the Supreme Court of Appeal judgment makes it clear that 6.2 adds to the arbitrariness of the nature of 6.1a, and says it reposes the minister vague and undefined discretionary power in relation to the retention of a fundamental right inextricably linked to other fundamental rights. And it mentions the other rights, and then it says, the SCA says, the minister is thus afforded unconstrained discretion without any guidance as to how such discretion is to be exercised. And it goes on. Clearly a violation of the kinds of ideas that this court as long ago as Dawood put in place. So
the only reason why I'm asking that is because when you were engaging with Justice Theron, you said, once we make a finding on 6.1a along the lines that you advance, it's not necessary to look at 6.2. I'm saying to you, it may be necessary in a judgment to look at 6.2 for this limited purpose only.
Yes,
the finding.
Yes, I think my debate with Justice Theron spoke to the order, and I think her question was rather, were 6.1a to fall foul of the Constitution, what would the nature of the order be, and should section 6.2 be tampered with? And my answer was it shouldn't be, because it's as far as the order is concerned, because it still can continue to live because of 6.1b. But as far as the point that Justice Majid, you making to me, we support the reasoning of the SCA in paragraphs 31 and 32 of its judgment.
Thank you. Thank you, Mr. Katz. Thank you, Chief Justice.
Any more questions?
Yes. I had lost connectivity, Chief Justice, so I apologize in advance if I repeat a question that's been asked, because I heard Justice Majid ask about the order. I wanted Mr. Katz to deal just with the question of retrospectivity and how practical it would be to go back to 1995.
Well, we make two submissions. The first is the default position is to go back to 95. And the only time that a court would deviate from the default position would be if there was some either evidence or argument about the potential disruption that retrospectivity would entail. And there isn't. There's no evidence and there's no argument that there would be any disruption or potential disruption. So we would submit the default position is the one that should follow. Also, quite apart from that question, the issue arises, well, an effective remedy to those who may be affected. And somebody such as Mr. Plyke when else could it be? It could either be, the order should either come into operation immediately rather than be retrospective, but that would mean that many citizens who lost their citizenship in an unconstitutional manner would not get the benefit of the order, and that would submit is not in the interest of justice, or not just and equitable, as the term is stated. I'm still very bothered, but I'm sorry to go on. I'm still very bothered. I can't answer Justice Majid's question because I know that it said that it's paragraph 50 of the answering affidavit where it is suggested that dual citizenship is not a problem, but I just can't find it, and I've gone through it over and over. And I know I've seen it, and he's right. I just want, anyway, if maybe I could, if Chief Justice, if you'd give me
can
permission,
continue looking for it, and even after the proceedings, you can send us a note telling us
that's
where
what I wanted to
exactly
ask
it
you.
is.
I'd ask for permission to do that. Because I know I'd seen it in just the same way that Justice Majid had seen it. I've also seen it, where it said Parliament, and it uses the word Parliament in particular. I've just lost it. Anyway.
Yes.
Sorry,
my last
Justice
question, Mr. Katz.
Yes.
Yes. I know I'd asked you earlier about loss and deprivation, and I don't mean to dwell on it, but isn't the distinction important, especially also if one has regard to Section 8(2) of the Citizenship Act, which particularly makes reference to deprivation?
Yes. I'm just...
So wouldn't it be important to understand what we're dealing with? Are we dealing with the loss of citizenship? If there's a distinction, firstly, and what are we dealing with here and the effect of the distinction?
Yes. Perhaps, Justice Duran, I do apologize. Perhaps you should help me. I mean, deprivation is an act by a particular office bearer, the minister. That's Section 8. Whereas Section 7, there's no act by any official such as the minister which causes the loss. And I think that's something it's part of why 61A doesn't serve a legitimate purpose in the sense of I've already articulated. So I'm not sure.
Thank you, Mr. Katz.
So just to turn on the real question is, I'm not just sure where, and I apologize, where that debate would take our argument. Anyway, so Justice Duran, I do apologize.
Is a loss of citizenship, does it equate to deprivation of citizenship?
No. Well, it doesn't. Well, it's not the same. They don't generate the same concepts. So deprivation is an active step by a government official to deprive somebody of something. Here, loss in the sense Section 6 talks to is automatic loss. It just happens by operational. There's no government official making any decision to deprive you of citizenship. I suppose one could say loss in Section 6 is...
So, if I understand your argument then, the loss of citizenship does not amount to a deprivation under Section 20. So it's not a contravention of Section 20 of the Bill of Rights. Because Section 20 says that a citizen may not be deprived of citizenship.
I understand.
So if there is that distinction, it means that a citizen can lose citizenship.
Well, losing...
And then, but not through an act of deprivation and not fall foul of Section 20.
Well, I want to answer it like this, and I don't want to how can I put this? Jump onto something that I have argued in a different way. Loss for purposes of Section 6 could be and should be considered as deprivation of citizenship by Parliament rather than by a minister. So it's deprivation. That's why deprivation and loss might have two different meanings in different contexts. So when Section 6 uses the word loss, that loss is a deprivation a la Section 20 by Parliament, not by a minister. But that's why I say it's a distinction without a difference. Deprivation in section 20 could include the loss by way of operation of law, which Parliament has affected, but not by a minister.
But there must be a reason why in section 20, the legislature uses the word deprivation, and why in section 3, the word loss is used.
I accept that. I'd have to accept that. But again, I say for purposes of, so in other words, the question then I suppose is this: on the basis that we come home on the irrationality of the section, that it doesn't serve a legitimate government, it doesn't serve any purpose, let alone a legitimate one, and the means and aren't connected to the means don't justify the ends. The question then must be posed: well, is the section one which violates section 20, which uses the word deprivation, and this is not a deprivation? Again, I'm going to come back to my initial submission, which I know the High Court didn't find favor with. The loss contemplated by section 6, we submit, would fall under the umbrella of the section 20 deprivation. And I understand the question that section 3 also talks to loss, but I stand by the submission that section 6 can be found under the umbrella of section 20's deprivation.
Why can't section 6 be found under the umbrella of section 3 of the Constitution?
It could in principle, but it could also be, we would submit that it also would fall under the umbrella of section 20.
And I don't mean to unnecessarily press you, but if you look at section 3.3, it says national legislation must provide for the acquisition, loss of citizenship.
No, it does. I can't get away
And
from that.
and doesn't that what section 6 does? It provides for loss, doesn't provide for deprivation. And for deprivation, we look at section 8.
Yeah, I take the point, Justice Turon, but I'm going to stand by my submission that section 6 does sort under section 20. I understand the proposition. I understand that that it could be argued that section 6 sorts under section 3, not section 20, but I would submit that it applies to both.
Thank you, Mr.
But then
Katz.
I mean, Justice Turon, in interpreting section 6(1)(a), we would submit that the citizenship right, which is a gateway right, we would submit should be given a generous and a broad meaning. And if there are two different meanings to be ascribed to it, I know the general rule will be that, well, you choose the one which least interferes with, or which better promotes and best promotes constitutional rights, and the Bill of Rights in general. And we would submit that however one interprets 6(1)(a), it would be better from a constitutional rights, Bill of Rights as a whole perspective, the gateway rights argument, that it be regarded as falling under the section 20 umbrella. That's the point. And then the question of section 36 kicks in, rather than to exclude 6(1)(a) loss from section 20 application at all.
I can understand why the applicant would press the section 20 argument, but thank you, Mr. Katz. Thank you.
But in any event, Justice Turon, I mean, the real issue is, well, I suppose the court could ask the question, do you need to go there bearing in mind the rationality debate, which is a different debate? So, we won on both legs in the SCA, and there's no reason, well, we would submit that we should win, that both legs should be confirmed, but it's not necessary if the section is struck down on the basis of either or both legs for purposes of the debate.
Thank you, Chief Justice. Thank you, Mr. Katz.
Any more questions, colleagues?
Chief Justice, can I just ask Mr. Katz something with regard to 6(1)(a), please?
Yes.
Mr. Katz, you mentioned that you can't interpret section 6(1)(a) without looking at 2. Is that right?
I'm not sure I said that, but I accept that for for purposes of the debate, yes.
Yes, because 6.1 starts off with the word subject to the provisions of subsection 2.
Yes,
So you have to look at 2 as well.
yes.
Now, the way I read 6.1a, it involves a voluntary act.
Yes.
Isn't that right?
No doubt,
And
that's
if a-
correct.
Yeah. So if a citizen of this country is embarking on some act to do away with his citizenship of this country, he can, in terms of section 2, then prior to that loss, apply to the minister for dual citizenship. Isn't that right?
That's correct.
So I'm struggling to see why the section should be done away with
So,
in those circumstances.
well, I'm going to rely, I'm not sure how to answer other than to suggest that the reasoning, very full and detailed and thorough reasoning of the Supreme Court of Appeal is correct. The first reason is that there's no purpose that is served by 6.1a if a person wishes to, open quote, give up their citizenship. There's no reason why
Yes.
they can't rely on section 7, the renunciation section. And the Supreme Court of Appeal makes the point that if the person that 6.1a contemplates is a person who wishes to give up their citizenship by, as you put it, Justice Seagoman, a voluntary act,
Yes.
what's the
Yes.
purpose of section 7? And becomes
Yes.
redundant. So therefore, section 6.1a must contemplate people other than the section 7 people. And what's the purpose of the section? And the Supreme Court of Appeal found there was no purpose, let alone a legitimate purpose. So that's the first answer. The second answer is the one that I've been having a debate with Justice Taron about, that
Yes.
it's a loss which is under the umbrella of section 20 deprivation without justification being satisfied under section 36. So those are the two legs of why we say that section 6.1a falls foul of the Constitution.
Yes. Yes. Thank you. Thank you, Chief Justice.
Colleagues, any more questions?
And Chief Justice, perhaps I should just, my junior reminds me to add a point which is made in the Supreme Court of Appeal's judgment that 6.1a, interestingly, and it's a point that's always, when I read it for the first time in 2016 for the purpose of this case, it always struck me that which is contained in paragraph 30 of the Supreme Court of Appeal judgment is should be of somewhat concern. And that is that even those people who've lost their South African citizenship by virtue of the implementation of section 6.1a, they themselves might not know that they've lost their citizenship, but also, and more importantly, or as importantly, the government might not know when or how it happened. And the argument that I'm pressed at the Supreme Court of Appeal hearing was that there's certain positions, a judge of the Constitutional Court, a member of Parliament, a whole range of administrative officials who in this country who, in order to be in the position that they're in, need to be South African citizens. And they wouldn't know, and Home Affairs wouldn't know, and Parliament might not know that by virtue of 6.1a, they actually are no longer South African citizens and wouldn't be entitled to be in the exalted positions they occupy within the South African public sphere. So that's something that my juniors reminded me to emphasize, but that is contained in paragraph 30 paragraph 30 of the SCA judgment, page 173. And that goes to its irrationality as well.
Mr. Katz, by the way, the portion that you was looking for is in exactly that paragraph, and that's the thing I also read, 173. Second line of the second line, the legislature is not against dual citizenship, we were told.
Yes, that's right. That's right.
That's what you were looking for, and that's
Yeah.
what I thought I read, yeah.
It was the
Thank
top
you.
of the, I knew it was at the
Yes.
top of the page. I just couldn't,
Yes.
but
Yes.
yes.
All
You know,
right.
yes, I've got a feeling it was in our learned friend, Mr. Macquarie's heads of argument at both the High Court and SCA level. That's where the sentence comes from.
All right. Justice Chip, do you have a question?
No, I don't.
All right.
Thanks, Chief Justice.
All right. Thank you very much for your submissions, gentlemen. The court will take time. Judgment is reserved.
Thank you
Court
very much.
adjourns.
As a pleasure of the court.
Today's proceedings have concluded. The host will now terminate the meeting.